Welcome back to More Law on Fox 19, your legal questions live, with local broadcaster and award-winning reporter Deb Haas and Cincinnati personal injury attorney Don Moore, recognized by Ohio super lawyers. More answers, more help, more law on Fox 19.
Welcome back. This week we are introducing your More Law Connection, where attorney Dan Moore will be answering viewer emails. Let's take it to Dan right now. Dan, you have a couple of emails I believe you wanted to talk about.
Yeah, that's exactly right. Thanks a lot, Deb. Good morning, everybody. It's good to be here. Today, our first question is from Frank. He asks, I am being evicted from my apartment because I'm behind in the rent. I lost my job 6 months ago, and I've been working with the landlord, but he won't cut me any slack. I need help. Well, that's one of these unfortunate circumstances where there really isn't a good answer for Frank there. When you can't pay your rent, whether that's because of a medical emergency, whether that's because you lost your job, you can't stay where you're living. You have to move out. Now, your landlord can voluntarily agree to help you out or to work with you on the rent, extend the time that he's going to allow you to pay. But if he doesn't do that, you can't make him. The best thing to do in those circumstances is to move out voluntarily. When you do that, be sure to know that if you have a lease, you're going to be responsible for whatever term is left on that lease. So, for example, if you have 1 year lease with 3 months left on that term, you're going to be most likely responsible for paying rent for those 3 months left on that lease term. If you have a month-to-month tenancy, then you can get out of there with less hit to your pocket. So bottom line is, if you're being evicted, you need to get out. Okay, our next question is from Marcus. He says, my brother committed suicide, and I think it was related to the prescription drugs he was taking at the time. I've seen ads on TV for this kind of situation, but the drug he was on wasn't mentioned. Can my sister-in-law sue the drug company on her own? Very sad situation, difficult case. The way most lawyers pursue cases like this is by looking for similar situations where people have taken the same drug and had the same reaction or a similar reaction, and they group those cases together because when they're together, they demonstrate that the drug can in fact cause this condition or problem. If you don't have a case that falls in within a group of cases that lawyers are trying to group together because they're similar, then what you're going to try to do is prove it on your own. That's more difficult. One of the things that you can do is take a look at your brother's medical records or ask your sister-in-law to take a look at those medical records. And if your brother, before he was on the drugs, if he was a depressed person severely, that caused him to perhaps try to commit suicide before or have suicidal thoughts, those types of things make it much more difficult to prove that the drug actually caused the suicide. Because after all, when you're talking about a legal case, what you have to prove in this situation is that had he not taken that drug, he'd still be here today. And that's a difficult thing to prove. So, if you have questions, feel free to send them to us. The way that you do that is to go to Fox19.com, click on the More Law button at the top of the page, fill out Send Us Your Questions form that you'll see there, then click Submit. We may even use your question on the show. Deb, back to you.
Thanks a lot, Dan. We'll look forward to seeing you here with us each week. Now, with me today, of course, is Don Moore. Don, you had a graphic that you wanted to show everybody.
Yeah, we had a case not long ago. You know, we're here talking about worker injuries today, and we had a case that we have many cases, in fact, where you've got not only worker injuries that make workers' compensation, but they also give rise to other claims as well. We've got a picture that we've got that shows a factory that was utterly destroyed because of an outside contractor's negligence. They let a piece of equipment not be maintained properly. It was leaking, it caused an explosion, it burnt the whole place down. Well, when it did that, it killed about 3 people in the factory and injured others. And the thing about that is we represented one of the workers. He was burned over 70% of his body. He had 23 different surgeries. It was just awful. His medical expenses were in excess of $2 million, and then eventually he died. And the thing is, if he just had workers' compensation, that would be a travesty. Well, he didn't. We also had a claim against the contractor who was supposed to maintain the piece of equipment, and it was one of the largest companies in the world. So we're able to recover much more than workers' compensation on behalf of that worker because of an outside contractor's negligence. That arises fairly frequently. And I'm sure, Catherine, you've seen similar circumstances, haven't you?
Oh, yes. quite a few work injuries have created situations where there was a third party that we were able to recover compensation from. For instance, a car accident. If you're in the course of your job have to drive around, you could be involved in a car accident. You would have a claim against that person. Or, for instance, I had a client who was installing a satellite dish and was attacked by a dog. He's got a claim for the dog attack against the dog owner. So, yeah, that comes up frequently.
Yeah, and one of the other things that's interesting is the subrogation aspect.
Yes.
You know, workers' compensation, when they pay for a worker and someone else has caused it, they also want their money back, and they'll even try and get ahead of the worker. So that's where you really need help from a lawyer.
That is correct, yes.
And let's see if we can give some more information to, let's see, it's Wanda in Cincinnati. Go ahead, Wanda.
Yes, I was hurt in 2008 on a job, and since then I have healed, but I had a claim in, and I was just wondering why is it taking so long, because it's been like 4 years since I heard anything, and the only contact I had was with the lawyers.
Okay.
But I was wondering why is it taking so long?
Catherine, do you see this happen where it does take a long time?
Yeah, it does take a long time. Wanda, did you say you do have an attorney?
Yes, from the company.
From the company?
The lawyer, well, a lawyer got in touch with me, and it's still, I don't want to name it, you know, what it's from, so.
Thank you for doing that. Thank you, Wanda.
Yeah, yeah. Well, settlement is a voluntary procedure. No one is going to force you to settle your claim, and no one is going to force the company or the BWC to settle a claim. So it's not like something that you can make happen. The best way to push a settlement along is to have your attorney contact the BWC or contact the employer and give them good reasons for wanting to settle your claim. Of course, they're going to want to settle your claim if they feel like you're going to cost them money in the future. So, but sometimes it does take a long time. Sometimes the company's just not interested.
And just like a regular personal injury case, you just don't know how long it's going to take. It just depends on how cooperative the parties are.
That's right.
Okay. All right. We'll take a break now. We'll be right back with more law. Stay with us. The Ohio and Indiana Bar Associations require we give the addresses of the attorneys on the show, so let's do that. Catherine Taylor Clements at Clements, Mahan and Cohen, 35 East 7th Street, Suite 710, 45202, 513-721-6500, and as always, Dawn Moore at the Moore Law Firm, 1060 Nimitzview Drive, Cincinnati, 45230-232-2000. You can get all the information at moorelaw.com. And we also want to remind folks that they can watch all of the other shows. If you go to Fox19.com and click on More Law, all of our shows will be there.
Yeah, I've had a lot of people ask me about that, and if they click on More Law, then all the shows are listed, and if they just click on that, it goes, I think it's like a YouTube thing or something, and they can watch all the old shows.
Okay, great. And I think we have time for a few more calls here before the end of the show. First, we have Dan from Cincinnati. Dan, you have a workers' comp claim. You were being paid, but some other issues arose. Is that right?
Yes.
Can you tell us a little more about what happened?
Yes, I was injured on the job, okay, and I was being paid wage continuation. And then it went over to, after wage continuation ended, it went over to workers' comp, which I would start receiving a third of what I was receiving when I was working. Then other health problems arose, and I went on Social Security disability. I'm wondering if there are still any responsibilities by workers' comp.
That's a great question. Dan, are the additional conditions or the new health problems related to the work injury?
Well, maybe not directly, but maybe indirectly, because I think it was because of a bad reaction from a combination of drugs.
Okay, well, the important thing to know is that if you do develop a new situation and it was caused by the work injury or sort of a flow through from the treatment that you've had for the work injury, if you have a doctor who believes that and will put in writing basically his opinion that it's related, you can file a motion to have that new condition put into your workers' compensation claim.
Okay, Catherine, I have a question. When a person like Dan hires a lawyer, for workers' comp claim. You know, for us, it's a contingency fee. We take a percentage of whatever we collect. And how do workers' comp lawyers get paid?
That's a great question. It's the same. We charge on a contingent fee basis.
Okay, so it's a percentage.
Yes, it's a percentage
and your percentages typically are what?
A third.
Okay. All right, very good.
Okay. All right, let us go to another call now. We have Neil in Northern Kentucky. How can we help, Neil?
Well, I was working for a company, and I had a couple of problems where I had a heart attack and I was in a hospital, and then later I had an infection where I was having dental work done and I was in a hospital. And they're on a point system, and what happened was after those things happened, I twisted my knee at work because I was doing 2 jobs because there weren't enough people to do the work. And in the process, I twisted my knee. So the next day was my day off. I finished that shift. Next day was my day off. I thought, well, you know, I twisted my knee, so it'll be all right. And the day after my day off, I went back in and went to work. And after a couple hours, my knee was all swelled up. It was hurting again. And I went up and I told the plant manager that I was going to have to go home. And he said, well, you can't do that. If you do, you're pointed out. You can't come back. So I told him, I said, you know, well, I can't work. I'm not going to, and you ain't going to let me sit here. So I went on home and was terminated. And I've had several people that have told me that I should file suit on them because, for one thing, they gave me points when I was in the hospital, and then they terminated me for something that happened there on the job.
What would you suggest that he do there? I mean, it's such a huge problem to tackle.
It is. You know, there is an Ohio statute that says that your employer cannot retaliate against you for pursuing your workers' comp benefits. I think I would say that assigning you points for missing work because of an injury would be a retaliation. So I think you do have a claim.
And I think Neil's in Northern Kentucky, if I recall. Do you know if that applies in Kentucky, or is that?
You probably should talk to a Kentucky attorney, but I have a feeling there would be some sort of protection for you in Kentucky as well.
Yeah, that's a big question. Can I be fired if I submit a workers' comp claim?
Yes. Yeah, that happens all the time.
Yeah.
I think we have time for maybe one more call here. We have Paul in Fairfield. Go ahead, Paul.
Yeah, I got a question for you. I was found maximum medical by my doctor in May, and pay for a self-insured employer, the third-party administrator, stopped the temporary total, and I was just wondering what would be my recourse from here on out.
Paul, if you were found at maximum medical improvement, did you have a hearing at the Industrial Commission where this was determined, or was it just their doctor examined you and said, we think you're at maximum medical improvement?
It was my doctor.
Okay.
And he submitted the paperwork.
Okay. If your doctor says you're at maximum medical improvement, really there's not much you can do to fight that. However, once you're found to be at maximum medical improvement, you can file for permanent total disability if you feel like you're permanently disabled, or there is a vocational rehabilitation program that you could apply for at that point.
We're just about out of time, Catherine, but you mentioned something before the show that I thought was very interesting that you think people should know, as far as a lot of people are self-employed these days and maybe they don't have workers' comp insurance.
Right. With more people getting laid off and maybe starting their own business and doing independent contractor type work, it's important to remember that you really should contact the Ohio BWC and purchase coverage for yourself, because you never know if your job involves driving around or whatever, you could get hurt. And if you haven't done that, if you haven't gotten the coverage for yourself, you're going to be out of luck.
Okay. Catherine Taylor, thank you very much for joining us today.
Thanks for having me.
And Don, next week?
Yeah, well, next week we've got a really great show, Divorce and Custody. But one of the things I wanted to point out to everybody, don't forget about our new More Law segment, Twitter, Facebook, email. You can contact us a lot of different ways.
All right, and we will be here next Monday morning at 9:30. We'll see you then on More Law.